With that, I'm going very good. I will hand it over to Emily in just a moment. Again, I just want to say this is a part of our regular community engagement series with the Housing Department and also part of Silicon Valley at Home's Affordable Housing Month programming across the month of May. So thank you for joining us, however you found us. There are many ways to stay in touch with the Housing Department, but please do sign up for our newsletter as sort of a key way to stay in touch with us. We will be exploring all the different rent stabilization and protection programs that we have here in the city of San Jose and a little bit about the history of them over the next 20 or so minutes. And then after that, there'll be an opportunity for Q&A. If you have a question during the presentation, please feel free to use the feature to ask a question. You can type a question into the Q&A question mark box, and we will field questions at the end of the presentation. But like I said, please feel free to type in a question and we will answer them at the end of the presentation. With that, I will hand it over to Emily to get us started.
Thank you, Sarah, and welcome everybody. I thought this would be a good opportunity to kind of look backwards at where renter protections have been in the city of San Jose over time, and then talk about more recent history, then what we're presently doing, and then looking forward. So first step, oops, there. So San Jose has a very long history of renter protections. I learned by chance reading through some council memos, one from 1986, that rent control was first attempted in San Jose during World War II when there was a population boom and a lot of different migrations happening for not great reasons and good reasons. And but a lot of that housing was produced post World War II, so that kind of laid low for a while. And then in the late 70s, there was a real increase in real estate values, which led to the adoption of an ordinance limiting rent increases in apartments and mobile homes in 1979. This is sort of like the start of the beginning of Silicon Valley. It was a very contentious debate, of course. And in the end, what resulted was not necessarily rent control, and even landlords admitted that there was a limit on rent increases, I believe 8%. There was no just cause, which is you have to have a legal reason to evict, which makes enforcing rent increase limitations a little bit challenging. So that ordinance was adopted September 7th, 1979, to address the substantial upward pressure on residential rent. Then the next major happening was in 1986. Rent stabilization was coming about in lots of jurisdictions in California, and it became apparent that they needed to separate apartments and mobile homes. The apartment rent ordinance stayed largely the same, but this city council during this time adopted a standalone mobile home rent ordinance, which had some pretty significant protections for mobile homes. And as for those of you that don't know, mobile home rent can refer to the space rent, where the resident owns their mobile home, but they don't own the land that it's sitting on top of. They pay rent. But this rent ordinance also covered where someone else, the park owner or another individual, owns the mobile home and rents it out to another individual. So it applied to both. The next major thing that happened was a state law that was passed in 1995 called the Costa-Hawkins Rental Housing Act. This law fundamentally shapes most rent stabilization rental housing laws in the state of California. One of the biggest things that impacted San Jose was that their apartment rent ordinance, and I believe the mobile home too, they had to roll back the date basically of when units could be covered. It's probably not the best way to phrase it. But whereas the apartment rentals are just covered buildings with 3 or more units, one of the things Costa-Hawkins did was basically prevent jurisdictions that had already adopted a rent stabilization or rent control ordinance, from having it cover anything after the date that it was adopted. So this influences who is covered by our current apartment rent ordinance, because it can only apply to buildings that were built before the adoption date, which was September 7th, 1979. This also applied to the mobile home rent ordinance in that if any space like this was permitted for electrical and sewer, like any mobile home space in a park, if they added any after September 7th, 1979, those would not be covered by the mobile home rent ordinance. So it's important to understand these things when thinking when I go over how the apartment rent ordinance works, to see what the significance of this 1979 date comes from. Right. So, not a whole lot happened between 1986 and where we are now, except, as we all know, there was a huge boom in the tech industry, which also, in addition to bringing tech jobs, all the people that would support businesses that support people working, so restaurants, childcare, janitorial, any other kind of business, because there was a population increase. This, as we all know, put tremendous stress on housing resources. And in 2015, the City Council directed city staff to explore potential modifications to the rent ordinance. There was a extensive city audit and report issued that shaped the actions that were eventually taken by City Council in the next few years, where they adopted the current version of the apartment rent ordinance with some amendments in 2018. And also, as part of this, there was exploration and adoption of what's called an Ellis Act ordinance. This applies to when units are being taken off the rental market, either to be redeveloped or to be used for another purpose, sold, just no longer rented out as residential units. Then in 27 and 2018, the tenant protection ordinance was adopted, which was a major win for renter protections. I'll get into why that is in the next couple slides. Also notably, where San Jose has been at the forefront of some renter protections is the adoption of the Housing Payment Equality Ordinance in 2019. This essentially prevents discrimination against renters who are paying with another form of payment, whether it be a third party or a voucher. And this was such a fantastic piece of policy work and legislative work that the state ended up adopting it when they passed the Tenant Protection Act in 2019. They pretty much mirrored the same provisions. And then in 2020 and 2021, San Jose led the way in probably, I think, adopting the first eviction moratorium in the state. I mean, they win that title by a day, or we win that title by a day. This was before the state took some actions months later. In addition to the eviction moratorium, there was also in place a rent increase moratorium for a certain period of time. And as a balance, property owners, the rental housing fees that pay for these programs were reduced considerably for a couple of years, taking into account the inability to increase rents and all the other challenges that came from the pandemic. Notably, since 1986, there has been pretty much no change to the mobile home rent ordinance, which is 40 years ago. The only change that was made was in 1993 when they changed from a 5% allowable annual increase to tying it to a percentage of inflation. But all the provisions and the way it's structured, the mobile home rent ordinance, is from 4 decades ago. So let's start with the apartment rent ordinance for those that don't know what units are covered, who is covered by the apartment rent ordinance. So it's only units in what we call multifamily buildings, which are buildings that have 3 or more units. And to be covered by the ARO, those buildings had to have been first constructed by September 7th, 1979. This includes what is defined in our code as guest houses Particularly in downtown area and around San Jose State, there's these large homes where there's communal areas, but separate rooms that are rented out. So our code inspection treats those as multifamily, and we consider it covered by the ARO if there's three or more rooms rented out. Um, the ARO covers even units that are where voucher holders live, where they use vouchers to pay a big chunk of their rent. The rent increase limitation is just to the part that the voucher holder pays, but that does not exempt them from the protections available in the ordinance. There's very limited exemptions, but what is not covered, and part of this is just the way our ordinance is constructed, but even if we wanted to, some of this we would not be able to cover due to the Costa-Hawkins Act that I referred to prior. So the ARO does not cover duplexes, single-family homes, condominiums, and of course, units and buildings that were built after September 7th, 1979. So what does the ARO do? This is very high level, but these are the key components. Number one, a tenant's rent can only be increased no more than 5% in a 12-month period. It requires that owners of these buildings register their units annually, where we get information about rents, changes in tenancy, what amenities are offered. The ARO allows tenants to petition the program before a hearing officer or request mediation if they are asserting that there's been an unlawful rent increase, if there's been some reduction in the housing services or amenities that were available to them when they first leased the unit, habitability concerns, housing code violations. What they can petition for is for some reduction in rent, which is typically temporary unless it's some amenity that has been permanently removed. An independent hearing officer hears these hearings that the landlords participate, and then a decision is issued. There's an appeal process where to appeal to the housing department if they want some portion of the decision reconsidered. At this time, it can't just be changed. We just evaluate whether the hearing officer looked at all the available evidence and applied the law, the right laws, and came to a reasonable conclusion that a hearing officer would come to. And at that point, it can be challenged in court. Property owners have a constitutional right, California constitutional right, to what is called a fair return on investment. And they may file a petition for fair return, asserting basically that there needs to be rent increases more than 5% due to increased costs or declining revenue, such that they are making less money than they were before, is the short answer. It's a little more complicated than that, and there's a lot of documentation that needs to be shown, and there's certain costs that can't be included. It's a large process, and we rarely get fair return petitions for apartments. Property owners also have the ability under the ARO to recover some part of their costs through what is called a pass-through that they apply for, and this is for capital improvements that provide additional benefit to tenants. So just merely replacing a roof or replacing the existing capital improvement that was there is not sufficient. That's just normal cost of business. This is if, say, the property owner has installed more insulating windows that saves on heating costs. Sorry, one second. I apologize. It's been a bad allergy day. Okay. So owners can file paperwork to petition to recover part of the cost for the improvement that they already did that adds benefit. Finally, there are joint petitions that would be filed jointly by the landlord and the tenant, or if the tenant brings in a roommate or an additional occupant, pet, or a second parking spot, and it's basically a formula for a one-time rent increase or charge to that they both agreed to. Sorry. There we go. So the tenant protection ordinance. The tenant protection ordinance is what we call just cause for eviction. Prior to this adoption and state law, if a property owner wanted a unit to be vacant or no longer wanted a tenant to reside there, provided there wasn't a year lease or something that was still ongoing, if the tenant was month to month, they would just have to give them a termination notice of 60 days if they'd been there over a year, or 30 days if they hadn't. Didn't have to specify a reason, just give them the notice and the tenant has no recourse. So that that became a real issue in as the housing crisis kind of grew and people were being displaced for people who could come in at higher rents, and it wasn't hard for property owners to do that. So they instituted a set of 13 allowable causes, and an owner has to specify the cause. In some cases, there has to be some prior notice if it was something the tenant did. And it's got to be written, and they still have to adhere to the timelines under state law. So this covers pretty much all multifamily buildings. It doesn't matter when they were built in the city of San Jose. It also specifically covers unpermitted units. So, and I'll get to that why, so that there's noticing requirements and relocation requirements. So that's the only other type of unit other than the multifamily. So as I explained, the owner has to specify a just cause for eviction. The notice that they provide to the tenant must have uh, no, a flyer that has resources for the tenant to contact to get help. And they also must file the notice with the city of San Jose within 3 days of serving it. Um, Owners must also, if they go to the next step, if a notice is given and the tenant doesn't abide by the notice or doesn't vacate, the owners can then file a court eviction. I'm sorry, an unlawful detainer, which is required in the eviction process. And that court document also must be submitted to our program within 3 days. And it can either of these, if either of these are not submitted to the program, it can be asserted as a defense to that eviction lawsuit. So of the 13 just causes, 8 are what we call at-fault causes, where it's because of something the tenant did or didn't do. Most common, it's not non-payment of rent, or non-payment of all the rent. And they would get a 3-day notice in that instance. Another common cause is breach of lease or nuisance. We don't see it very frequently, but owners are required to give pretty sufficient detail in notices if it is something regarding the breach of lease or nuisance or criminal activity. There are also 5 no-fault causes where it's nothing the tenant did. The landlord wishes to do something different with the unit. It could be that the owner is moving into the unit. It could be that the owner is doing substantial rehabilitation, which has its own requirements. But for all of these 5, where no fault causes, where the tenant did not do anything, relocation assistance is required to be paid. Or so for ARO units, for units that are only covered by the TPO, there needs to be a service provided to help them find. Oh, that's under the LSI, excuse me. But under the TPO units, they might have relocation assistant payment rights under state law. So those are, yeah, so those are the requirements under the TPO. Finally, the mobile home rent ordinance. So everything I just covered does not apply to mobile homes. We still have that ordinance that's been largely unchanged for 40 years. As I explained before, it covers all mobile home spaces permitted before September 7th, 1979. That's most of them in the city. And it also covers rents for rented mobile homes occupying covered spaces. The main component of the mobile home rent ordinance is that annual rent increases are limited to 75% of the change in the consumer price index, which is an inflationary measure. There is a floor, so if that calculation ends up being below 3%, the owners can still raise the rent 3%. And there's a ceiling where if we get into an era of rampant inflation, it would be capped at 7%. For 20 plus years that I can see going back, there's only been one or two times where the calculation was above 3%, and that was during the pandemic. And it was still between 3 and 4%. A big thing to note is that the MRO has what we call vacancy control. So when a mobile home resident sells their unit to another person, that new owner stands in the prior owner's shoes. They're still paying the same amount of rent. And so the rents strictly in mobile home parks, except for some limited circumstances, will only go up by the typically 3% allowable increase every year. So if you have a mobile home rent amount from 10 years ago, and even if that had gotten sold, you probably can calculate what the rent is now. They can't, as this is in contrast to apartments in across the state of California, including San Jose. There's Costa-Hawkins also required vacancy decontrol. So when a tenant moves out of the unit, the owner can set the price to market or to whatever they want. They're not restricted by the 5% that the ARO allows. And just like the ARO, because this is a California constitutional right, a park owner may petition for a fair return to increase rents of all the spaces above the maximum allowable if their revenue is not keeping up with expenses. I also thought it would be helpful to kind of give people a map of where all of our mobile home parks. I'll note that California, in the state of California, San Jose has the most mobile home spaces of any other county or city jurisdiction. And I believe I've been told that we are number 3 in the United States, and that the two other cities with the largest amount of mobile home spaces are in Florida. So it's 10,741 spaces, most of which are covered by the MRO across 58 parks. 11 of these parks are 55 and over only. So this is an incredible resource for seniors to have home ownership, but live in a more affordable unit. Across our mobile home parks, it's not just mobile homes or what we call manufactured homes. Um, Many of them house RVs and trailers, and not the manufactured kind of like wood structure home with or without foundation. Um, Our program goals across all of our ordinance, as Sarah alluded to, the staff of the rent stabilization program spends a lot of time out in the community because one of our main goals is outreach and education to tenants, property owners, and residents on all the city's rental housing laws. These laws don't work unless people understand their rights and responsibilities. Um, we also have goals, which is outlined in our strategic plan, to collect as much data as we can on our activities and on the data that we do collect to streamline the implementation of these ordinances and better inform our policy decisions. Uh, our third goal is supporting tenants and residents with their renter protections and housing stability, getting them connected to resources, helping them solve problems before they might be threatened with eviction. We also have a goal of supporting property owners in maintaining and preserving San Jose's naturally occurring affordable housing stock, which mobile homes and the units covered by ARO are considered part of that housing stock. So what we mean by that is we are trying to find ways for them to improve or sustain these units and ensure housing stability, so they don't fall into disrepair, in keeping up with different regulations. And you can find out more about all of the ordinances at sjhousing.org. But as I said before, I was going to turn to what is in the future. So if for those of you that aren't aware, the Housing Department has put forth proposed updates to the MRO, and we are conducting outreach over the summer regarding proposed changes to the MRO. And the goals of these changes are to create, number one, to create mechanisms for residents to enforce their rights and mechanism for owners to achieve a fair return. Right now, our program is very limited. What I didn't note before was that we calculate what the rent increase is. We process fair return petitions. We take calls from residents and owners about issues and try with no enforcement tools to resolve or connect them to legal services or mediation. But all of the infrastructure in mobile home parks is governed by the state, the HCD they call it, but the state oversees a large chunk of regulatory programs over mobile home parks and mobile homes. So we don't have as many ways to resolve those issues. We can refer residents to the mobile home assistant line that's by the state, but we don't have any other enforcement tools. So if a resident thinks that they are being overcharged or there's some other dispute about their rent, they have to go make a complaint at the state or possibly file a court action. We don't have any mechanism for them to address that. In addition, we want to improve data collection and increase transparency, and the main way to do that is to have a rent registry like we do for our ARO. Right now, I can't tell you what the rents are across mobile homes. I can ballpark it from what we see in listings and some info we gather anecdotally from people, but we don't know we also don't know how many mobile homes are rented versus owned by someone. We don't know the turnover rate of mobile home spaces. So one of the proposals is we have a registration requirement for owners, but it's primarily so we know who the owner or the operator is. And it's not, we send out the form annually, but that's it. That's just who owns the park, how many spaces are there, who manages, if it's an on-site manager. So we're proposing a rent registry where park owners will be required annually to report changes in rent, changes in turnover, and what spaces are rented or what mobile homes are rented versus owned. This would mirror many other rent registry. This is how we would learn what is actually happening and be able to make policy decisions based on what we're seeing. Right now, we don't have access to that data. It's very difficult to get. Even when mobile home parks are sold, they're not always listed. So while we check listings for ones that are, there are private sales that happen, and we often don't learn about it until afterwards. Also, a lot of the amendments proposed to the MRO really relate to hearing processes and program administration that are stuck in the 80s. And we very much need to modernize it and make things more flexible for processing petitions and more efficient, and not having to throw a whole bunch of resources to make got some timelines that were made up 40 years ago based on not a lot of prior experience. So we're hoping that this group can go and learn more. We have a page. If you go to www.sanjoseca.gov/mobile homes, you can learn about the proposed changes. There's a survey that we'll be running all summer. Currently, we have the link posted for English, but we are doing we'll be posting that survey and the supporting information in Spanish and Vietnamese. We will be holding office hours beginning at the end of May. We will have, and the dates for those are also on the webpage. We will hold 3 sets of 3, and we will have an English only office hour, Vietnamese only office hours, and Spanish only office hours. We'll go over the current constraints of the ordinance and what we're proposing and allow people to and take people's questions. And we'll gather that feedback and develop an FAQ. But this is happening over the summer. So the first set starts May, and then it'll be July to August, and then into September. We'll also be doing direct stakeholder engagement over the summer with park owners and park residents and advocacy groups. So I encourage you to visit that page and learn more. And I think I've probably gone way too long, so we can open it up for Q&A, Sarah.
No, excellent, Emily. It really, it's so much information in such a concise manner, and I want to say thank you both for the presentation and to you, Emily, and to your team who are here or actively working to help members of our community in their work. I'll remind the group, please submit questions via the Q&A question mark box feature. We're limited questions at the moment, but let's start off with a question on, there were a bunch of proposed changes to the mobile home rent ordinance that came to council in January of this year, and now essentially they were sent back to the department to do further community engagement work. A question clarifying, someone's asking, they thought that there already was a rent registry for mobile homes. Can you explain sort of what exists today and what would be filled by the proposed kind of updates around the mobile home rent registry?
So what I was trying to describe before is that the only requirements in the ordinance are that when a park is sold or park is management has changed, that the program needs to receive notice in within specific time frames. As a matter of course, over the decades, the staff sends out the registration form saying, here's your opportunity to tell us. But that's the only thing that's required is the information on this form, and it's only the park owner, address, who to serve, things, and if there's an operator or manager that's different, what is their contact information, and do you have any exempt spaces? There are a couple of exemptions, one being they constructed more spaces, but they're not covered by the MRO, but we still want to log how many spaces there are. And what's been sunsetted at the state and still will exist till the leases end, there was a long-term lease exception. So that would be the place where they would tell us how many spaces are exempt and how many spaces are in the park. But it's very limited information. And there was nothing, out of course, we did it annually, but there's nothing in the ordinance about it being annual.
Great. So here's a question anonymously submitted. How would the upcoming community outreach impact the proposals? Is there a possibility of the proposal being fully dropped? I will just quickly answer that because this is city council referral, that it came to council, it was referred back to the department to return to council. It will be returning to council. But I think probably embedded in this question is perhaps, what does community input look like? And maybe, Emily, you want to speak a little bit to some of the planned efforts that are going to happen throughout that community outreach. So just to be clear, this is something that council is the decision maker and the policy makers in the city. It will be coming back to council later this calendar year. But speak to some of what the outreach will look like, and then we have another question.
Sure. We did perform outreach prior to the city council meeting, but it was largely in a large group format, where in some instances the more vocal or louder voices got heard, and we wanted to give people who maybe want to look through these changes and uh, try to understand them better to be able to give us feedback. So we're approaching our outreach in a number of different ways. I mentioned the survey, which is very open-ended, where we are asking for your written feedback if you want to give it, and that will be organized and questions will be addressed along the way. So that's open to everyone, and it will be accessible in 3 languages. We will be holding it open for almost 6 months. Um, and we will be sending radio ads on Spanish language and Vietnamese radio, directing people to a short website name that we just had so they can access this information. We will have flyers. We're going to do mailers to all the parks with QR codes, links to the office hours that we'll be holding over the summer. Um, we will be doing direct engagement with park residents where parks are friendly. We will hold where the park owners are friendly. We will work with them to hold a meeting on site. So we want people to be able to engage with us in a number of ways, whether it be written, whether it be during informal office hours, or whether it be in an organized fashion. But we really want to hear people's thoughts on each of the proposals. That's really the goal, and what we were lacking in the first round.
Okay,
Excuse me.
great. Thank you, Emily. Here's another question. Are there any senior rent freeze programs or senior rent exemptions? This person makes a reference to SCREE, which is the Senior Citizen Rent Increase Exemption in New York City, asking about any kind of senior exemptions or programs available to senior renters in San Jose.
There is no program that's tied to the increase of rents or in the MRO in the past, and we hope to have in the future. We have directed funds towards um, low income like repair programs, which um, there's actually 2 earmarks being put forth by Congressman Ro Khanna and Congressman Liccardo that would be specific to mobile home repairs for seniors. So we
And Emily,
advocate
what about the ARO?
the ARO. We do not have any programs that are attached that are connected to the ARO like that.
Oh, okay, great. Um, a follow-up question. Could you help explain the meaning of 8 and 5 causes? So this is around the different causes for eviction. So it's the 13 causes. If you can just kind of, you might even have a slide you could scroll back to.
I can scroll back to and then I can read off
Great.
I apologize that I didn't do. Okay. Scroll back to.
I will say to the person asking this question, this is I think as much as we try to make legal language accessible, it is not the most obvious.
Okay. So 8 of these causes for reasons to evict are because the tenant did or didn't do something. They didn't pay the rent is one. The second is material or habitual lease violation. Um, Smoking, that comes up. Um, Damage to the apartment. Um, and again, with some of these, there's a precursor notice where they have to be given an opportunity to correct the problem before. Refusal to sign a new agreement. This one gets a little confusing. This is what most frequently happens is there's tenants who are month to month, and then the building gets sold and the new owner, property management, just wants to have everybody on the same contract terms that are not different from what we say materially different. So if people are refusing to sign an agreement that was substantially the same as the prior, that can be a reason to end a tenancy. Nuisance behavior is number 6. An unapproved holdover subtenant, which is a very specific situation. Um, Criminal activity. I know this one had a lot of debate. Again, we don't see a lot of notices with these types of things. So those were the 8 at fault, the number one being non-payment of rent. And then the other 5 are where the owner is doing something different from renting out the unit, or there's something they're entitled to do. So there could be an Ellis Act. That could be the basis, which I referred to before, which is I'm not going to rent out these units anymore. I'm going to turn it into condos and sell them off. There's all sorts of requirements for it, but it is a valid reason to terminate or end a tenancy, evict someone, and pay relocation assistance and give them a certain amount of time. Substantial rehabilitation, they can't just really say that. They have to have pulled permits and shown that the work is going to take a certain amount of time. Owner move-in. An owner, their kid, they want to have them live in the unit. They have to intend to do so for 36 months. There's other requirements, but this is, again, not the tenant's fault. In order to vacate, that's typically when code comes out and either there's an unpermitted unit or there's the condition of the unit is not habitable. That is also a failure on the part of the owner, not the tenant necessarily. And then the last one is converting an unpermitted apartment for permitted use. So they have to pay relocation assistance, give a notice before they do what they need to do to make that unit permitted. And then the tenant does retain some rights to return. So that's a detailed list of the 13.
Thank you, Emily. Okay, here is a question from a landlord. I own an apartment building. There are tenants who have been unable to pay or only partially pay rent. They have accumulated a large amount of back rent. I'm sympathetic with their financial situation. However, I cannot afford to let the situation continue indefinitely. I don't want to evict them if possible. Where and how can they get help?
So the first thing I would suggest is to contact our program and also provide information to the tenants. Our staff can give you social services information, the homelessness prevention system, but also we contract with a third-party neutral agency called Project Sentinel, who provides tenant and landlord counseling, dispute resolution. I'm a former mediator myself, and my inclination is let's try to see if an agreement can be crafted so tenants can make good faith attempts, and that if the agreement is not, if it's breached, if it's someone fails, then you can take the next legal actions. But I really encourage tenants and landlords to work together. And if you contact our program, our eviction prevention program particularly, same number, most of the same people. We do our best to try to get people connected to resources that might be out there.
Okay. Okay, there's a question just about the eviction support study, asking where it is on the website. We will make sure that staff send out the link. I know it's in the queue for an email blast, as well as some social media pushing it out. You know, one of the great things about our city's website is that it has a lot of information. One of the challenges about our city's website is that it has a lot of information. So I understand that we've received some feedback around this, the draft study not being the most easy to navigate to, and we will make sure that it's linked out after this, after we're done with today's session. So let me go on to the next question. Who does the renter reach out to if they are dealing with a lockout, that if the owner has changed the locks of their unit, which they believe has been done illegally? Who is the best contact in that situation. And I will say, if someone is in that situation, I'm very sorry. And Emily, please
Yeah.
enlighten us.
Yeah, that's definitely a prohibited action and what we call constructive eviction. We really would like people to contact our program first, and I'm remorse to not putting the phone number up. We'll get it and be able to give it to you. We may not be able to specifically help, but we want to know what's going on and we can help tenants. We do have contracts with legal services and other resources. But we also, as a program, log every interaction that we have regarding a property. And so the more information we have about this happening, I know that it's technically illegal and theoretically you could call the police, but I know from past experiences, I mean, they could try that too, but police often don't want to determine. But the only person who can lock a tenant out is the sheriff after a whole court process has been followed and a writ has been issued. Landlords are not entitled to lock tenants out.
Okay. Um, well, we're getting down to the final question or so. So I will just say we're welcome to continue for at least a few more minutes. So please, if you have any additional questions, please feel free to type them in into the Q&A feature. Um, with that, I will just ask a final question, which is that 5% on the apartment rent ordinance sounds like a high number, that's not necessarily the stability that one might want to see. A question of how does 5% compare to other cities with rent restrictions and rent control? And are we seeing most landlords take advantage of the full 5%, and do we know kind of how that rounds out every year?
So we've been looking at tenants who've stayed year to year in the rent registry. And I think the most recent sort of average of same tenancy has been about 4%. So year over year, the curve's really interesting lately when you look at median rents, but it looks as though many property owners are not taking advantage of just hike it up every 5 years. Typically, I know some
Sorry,
smaller,
that they're not
so-
taking full
sorry,
advantage of 5% each
every
year.
year, yes.
Okay.
And we've also noticed in some smaller buildings where more individual owners, they only raise the rent every couple of years. So we're trying to get a better picture because you just look one year to the next, but it's like, well, no, what's it really look over time for certain tenants?
Okay.
And we are at uh, for the most part, we're at the higher end at 5%. Hayward has a very similar law. Many other cities, I forget the count, there's a lot now, tie their allowable increase to the rate of inflation, which is the consumer price index.
Okay. Excellent. Well, with that, I will say that is our last question. We will send out an email with some follow-up information that was obviously requested and discussed across the presentation and the Q&A. Please feel free to reach out to us if you have questions about something going on with your rent, or if you're experiencing any challenges. You can easily find the phone number of the housing department online, and we will figure out the best resource to connect you with. Thank you everyone for joining us. Happy Affordable Housing Month, and we will see you next month. Take care, everyone.
Bye. Thank you.